statute and on procedure. Most of the members of the court, when you came for us last time, indicated we thought some factual development might be helpful because of the competing questions of fact. The statute seems to suggest that the circuit court should separately treat disputed issues of fact. As Justice Ann Bradley pointed out, we have some findings here. So my question to you is maybe more arcane, but an important one, which is, how should we look at these findings of fact? Should we defer to the circuit court's findings of fact in this situation, or do you believe a different standard would apply under Chapter 9 here?
Well, first of all, I think that under Chapter 9, you're actually reviewing the canvassing board's decision and not the circuit court's decision. The circuit court is in effect reviewing whether or not a specific finding or conclusion of the board was supported by the evidence or by the law. In this case, I think what we have is that there were certain findings by the boards, which then became ultimate findings here. And as the judge reflected, and I don't disagree with his general statements on this, which was that as we originally in our original petition, which the court couldn't know at the time, but I think now the record reflects, is that there's not a substantial difference of opinion between the two parties on the essential facts in this case. That was one of the things that we didn't know going into the recount, what in fact would be the kinds of factual disputes we'd have. But as the record reflects, as the recount progressed, we were able to isolate specific ballots and specific categories, and people were not disputing, for example, that certain ballots had been changed or altered. And they were not disputing that it was done by the clerks, or in the first instance, that the applications weren't submitted. There were no applications other than EL 122. So as to the essential facts in this matter, I really, as I felt all along, but I certainly feel now the record reflects, they're not substantially disputed. That's why earlier when Justice Bradley, Ann Walsh Bradley, was asking that question, I might have looked a little hesitant, because as to the essential facts here, I don't believe that the judge's opinion was much different than what we ultimately think, which is that the facts here are pretty straightforward, and it's the legal conclusions.
You're coming